247158FH, 247178FH, and 247184FH. Time and date set for hearing. Mr. Talisman appears from the Sanilac County Jail, represented by Attorney Roberts in this matter, Karen J. Roberts. Appearing on behalf of the people of the state of Michigan, Assistant Prosecuting Attorney Alexander Pani. We had adjourned the proceeding previously regarding issues of contact with the client, making sure the defendant was present. Obviously, the defendant is present. Ms. Roberts, are you ready to proceed with your motion?
Yes, sir.
Please, go ahead. Thank you.
All right. Just a couple of clarifications regarding the bond motion itself. One is in paragraph 1, according to the prosecutor. Well, let me step back a minute. There are 3 bonds. One for 7158 is at $50,000, and then it's 100,000 cash or surety, and then the other one is 10,000, 10%. That is, I believe, the correct bond amounts. According to the court rule and the case law in this matter, every defendant is entitled to bond, a reasonable bail anyway, and also pursuant to the United States Constitution and the Michigan Constitution. Michigan Constitution is Article 1, Section 16. I'm sure Your Honor is aware of this. What is important is under Stack versus Boyle, it states that bail should be set at an amount higher, not higher than is reasonably calculated to give adequate assurance to the court that, I'm sorry, Your Honor, that the accused will stand trial and submit to sentence if guilty, if he is found guilty. Reasonable bond in this matter, we submit, is not 100,000 plus 50 plus 10%, which is altogether 160,000. And I believe the only 10% was on, and I actually don't have that in front of me. It might have been the $50,000 one. I'm not sure. Regardless, there are a lot of factors to be taken into account by this court as far as a reasonable bail. Of course, one of them is the seriousness of the charge, and these are serious charges, but I submit not serious enough for that kind of bond amount. Mr. Talisman has lived in the area his entire life. He of course bears responsibility for the charges, but the victim also bears some responsibility because of.
Everything changes right here. The prosecutor argues that the defendant isn't dangerous because of drugs or alcohol, but because these alleged crimes happened while he was completely sober. That single statement could have a huge impact on how the judge views this case.
The actions that happened. Mr. Talisman has a 7-year-old daughter that he's very close to. He and his ex-wife, Angela, who I believe is in the courtroom. If not, then she could not. I'm not sure if she is. Oh, she is. Wonderful. And she would be willing to be like a third-party custodian to make sure that he follows all the rules of the court. If he is released on bond, make sure that he makes all his court appearances. And considering the contact that I've had with Mr. Talisman, he will do that. He will make every court appearance. He has never failed to appear in court. He has no criminal history. He has many ties to the community. He has no substance abuse issues. He doesn't drink. He stopped drinking years ago. He has no drug problem, no illegal drugs, not even pot, even though it's legal here in Michigan. And I submit, Your Honor, that with all those things, he would most assuredly appear in court for all of the court appearances that are necessary. And if found guilty, he most certainly would submit to the sentence that he is given. Based on those things, I'm asking for a reasonable bond, possibly a 10%. 10% of 160,000 is still a lot. So I would ask that the bond be reasonable, or that he be released on his personal recognizance, considering he's never failed to appear before.
Anything else, Ms. Roberts?
No, sir.
Thank you. Mr. Pop.
Thank you, Your Honor. What's most concerning here, Your Honor, are the seriousness of the charges. And of course, bond is decided on both risk of flight and a defendant's danger to the community. Danger to the community is the factor which the court must take into consideration. We have no doubt about Mr. Talisman's risk of flight. That's not an issue based upon any prior interaction with the criminal justice system. However, his danger to the community is significant, as the court can see from multiple felony files occurring across multiple counties in our region. One in Sanilac County that the people of Huron County have assumed jurisdiction on, as well as 2 additional felonies here in Huron County. So not only is he a danger to individuals in this county, but also to our neighbors to the south. The allegations in this case are serious, Your Honor, in that the defendant allegedly committed a home invasion in Huron County, illegally entered a computer system to locate GPS information on an individual who had a PPO against him, used that GPS tracking data to locate her in Sanilac.
Everything changes right here. The prosecutor argues that the defendant isn't dangerous because of drugs or alcohol, but because these alleged crimes happened while he was completely sober. That single statement could have a huge impact on how the judge views this case.
County traveled there, committed a home invasion, injured another individual so severely that he had to be transferred to a high level of trauma care. And if, Your Honor, I certainly take Ms. Roberts' statements as correct, that there is no substance use disorder here. But my gosh, Your Honor, if there was, at least Mr. Talisman would have an excuse for these allegations if he was high or drunk or something. But all of these allegations allegedly occurred while he was sober, which makes him, Your Honor, even more dangerous to the community. I would end, Your Honor, by saying that at the close of the preliminary examination, sua sponte, on the court's own motion, the court increased bond after hearing the facts of the home invasion first-degree case. The people did not motion for that bond change. The court did it on its own motion after hearing all of the facts and binding him over to this honorable court. We believe that the bonds are appropriately set and would ask the court to deny the defendant's motion.
Your Honor, if I may respond.
Oh, no, please. I always allow that opportunity. Go ahead, please.
Thank you, Judge. The prosecutor is talking about multiple counties, and he's making a scenario much, much worse than it is. The 2 counties are obviously right next to each other. One county was in 1 mile of the other, which is the reason that this has been Huron County rather than Sanilac County. And the other thing is that the prosecutor is saying has to do with allegations. Every single defendant that I have ever represented has been presumed innocent. And it sounds simplistic, but he's innocent until proven guilty. The way the prosecutor is talking is that he's already been found guilty. A lot of the facts in the preliminary hearing contradict one another. So I don't believe that he has the grounds to say that he illegally entered into a computer. Those are the facts that he was told by one of the victims. He doesn't know, or if he does, he's not acknowledging it, that there are other matters that are part of this case. And one is the fact that the victim has an issue with first getting the PPO when she had an argument with Mr. Talisman, and then she got a PPO for him, and that between the time that she got the PPO and this incident occurred, they were back and forth seeing each other. She wanted to see him. She went to see him. She spent the night. There were numerous times that the parties had were intimate. All of this is part and parcel of all three cases. And as far as danger to the community, he can wear a tether. I'm not sure if it's possible to wear a tether, if you have the facility to do that, but he would be more than happy to. And he will not, under any circumstance, seek out any contact with, or for sure not, the other victim, Dan.
Ms. Roberts, would your client be residing?
You know, that's one thing I didn't get, Your Honor, is his address. Mr. Talisman.
Yes. That is my home address.
That's where he'd be residing if bond were reduced?
Yes, Your Honor.
Yes.
Well, the court has to consider MCR 6.106. That is the court rule the court applies relative to any pretrial release. Clearly, these are not capital offenses, murder or treason. Now, considered a violent felony at the time, and under the court rule, at the time of the commission of the violent felony, the defendant was on probation, parole, or release pending trial for another violent felony. That's not the case, nor does Part B apply as well. Now, a violent felony within the meaning of subrule B1 is a felony, an element of which involves a violent act or threat of violent act against any other person. So clearly, bond has to be set that is appropriate. And for the record, I've not reviewed the preliminary examination transcript. I have no idea regarding the allegations other than what's contained in the information. And the reason the court does that is the court doesn't want to have any preconceived notions relative to the status of the matter other than what the information reads, what's contained within the file. So when the court considers money bail under 6106E, the court also has to consider and state for its reasoning on the record statement of reasons under paragraph F. And the court has to consider the following. One, or paragraph A, defendant's prior criminal record, including juvenile offenses. According to counsel, there are no criminal records of the defendant. I've not heard anything relative to either counsel responding with any juvenile adjudications. Part B is defendant's record of appearance or non-appearance at court proceedings or flight to avoid prosecution. There's been nothing on the record, at least, to indicate that he would not appear. Counsel has stated so as well. Mr. Pahani's primary concern, and I sincerely understand that, would be as we move forward in these considerations. There's no history of substance abuse or addiction. Regarding mental condition, including character and reputation for dangerous, all I have are the charges that were presented. Paragraph E, and this is Mr. Pahani's concern, the seriousness of the offense charged, the presence or absence of threats, and the probability of conviction and likely sentence. Clearly, the defendant is charged with rather significant felonies. In 7158, the defendant is charged with aggravated stalking, which is a 5-year felony. In 7178, the defendant is charged with home invasion first degree, a 20-year felony. Assault with intent to do great bodily harm less than murder by strangulation, and that's a 10-year felony. Again, aggravated stalking involving the same alleged victim, a 5-year felony. And interfering with electronic communication, a simple 2-year felony. In 7184, defendant is charged with home invasion second degree, 15-year felony. Using a computer unauthorized access to commit a crime. I'm sorry, that's count 3. Count 2, unauthorized access of a computer, 5-year felony. Computer used to commit a crime, a 7-year felony. as well as aggravated stalking regarding the same alleged victim, 5-year felony. So, and the court has to consider if there's a conviction, what the potential guidelines could be if the defendant is convicted, and it appears to be rather significant. Now, putting that aside, again, I also have to consider, the court has to consider not only the seriousness of the offense, defendant's employment status and history. As I understand it, according to the motion, prior to being charged, the defendant was employed. The availability of responsible members of the community who would vouch for or monitor the defendant, that was brought up by Ms. Roberts as well as facts indicating the defendant's ties to the community, including family ties and relationships and length of residence. He's been a resident of this community essentially his entire life. Finally, any other facts bearing on the risk of non-appearance or danger to the public. I don't think there's a concern regarding showing up for court. The issue, though, is the potential dangerousness to the public. And when you have 3 allegations of aggravated stalking involving the same alleged victim, that is clearly concerning to the court. Home invasions, obviously very significant as well. Again, I'm not doubting the examining magistrate who on sua sponte, on his own initiative, had modified the bond. But under the circumstances of this case, at this point, regarding the defendant's lack of any criminal history, the court is going to modify the bond. The bond in the first file, 7158, was originally set at $100,000 cash or surety. That bond will be lowered to $100,000, 10%. In case number 7184, the bond will be lowered to $5,000, 10%. Let's see, I have this right. And on the last file, I'll reduce that to a 10% bond as well. So whatever the cash surety bond was in that file, the court will reduce it to a 10% bond. All other conditions as entered by the examining magistrate will continue, but the court is also going to require that the defendant be fitted with a GPS tether. That is to ensure that he is in any way, shape, or form not around the alleged victims involved in this case, which include, that is the bond that the court will enter in this case. Ms. Roberts, do you have any questions?
I do, Your Honor. Just for clarification, when there's 3 separate files, so there's a 10,000, this is if it's 10%, 10,500, and then 10% of the 50. I'm not sure what the other one was, but they're all 10%. Would they be added together?
They'd all have to be posted, yes.
Oh, for each file?
Yes, for each file.
Okay, and there's nothing more in the bond. I do have some questions, though, about our future court dates. But okay, this matter then would be settled as far as we're concerned.
All right. Well, let's go off the record then, and we can discuss court dates. Can we go off the record, please?
Your Honor, before we do.
Oh, okay, we'll stay on the record.
Just for clarification's sake, I believe the court might have misstated the case number. So 7178 will be converted to 100,000, 10%. Is that, and 7184 will be converted to 5,000, 10%.
Yes.
And 7158 will be converted to 50,000, 10%.
That's correct.
Thank you, Your Honor.
Totally different numbers.
Do you really?
I'll get with you.
I have them.
Okay. I apologize. That's what happens when you go on vacation for a week. All right. Anything else before we go off the record?
Nothing from the people.
Ms. Roberts, anything?
Nothing for the defense, Your Honor.
All right. Thank you.
If you thought that courtroom moment was unbelievable, you're going to love what's coming next. Hit subscribe so you never miss the most shocking courtroom stories from across America. Thanks for watching, and I'll see you in the next case.